Our lawyers for the NDC's 2020 presidential candidate on Thursday failed yet again in the attempt to get the chairperson of the Electoral Commission to answer some 12 questions they had for her. A 9-member panel of justices dismissed John Mahama's review application after the court presided over by Chief Justice Enini Yeboah said the threshold required for the court review jurisdiction to be triggered had not been met. Court correspondent Joseph Akable has more.
Hearing commenced on Thursday with the panel informing the lawyers in the case that some of the applications that had been made were moot. The first had to do with a request that the court stays its proceedings. That particular application should have been heard on Tuesday, and because it was staying proceedings pending the court dealing with the review on Thursday, the court did indicate that it was moot, and so Mr. Chikata, who had filed a particular application, proceeded to withdraw it, and the court struck it out as withdrawn. The second one related to a request for abridgment of time. It was a request that the Electoral Commission had made, asking that the court hears the review on Tuesday instead of Thursday. And because it was Thursday again, the court did note that it was also moot, and lawyers for the Electoral Commission proceeded to withdraw that particular application as well. With that out of the way, the court went on a brief recess where 2 justices of the Supreme Court, Justices Professor Henrietta Mensah-Bonsu, as well as Justice Amadou Tanko, joined the 7-member panel to now make a 9-member panel, at which stage the legal arguments were listened to from Mr. Chikata, Justin Amenuvo for the Electoral Commission, and Akoto Ampao for the President Akufo-Addo's legal team.
It's my submission that the arguments we have heard today by the applicant is just an emotional reaction to an unfavorable judgment quoting Adade, and therefore this application should be dismissed. That's my submission.
The applicant has the burden of demonstrating to the court how the refusal in this particular case was wrong. And furthermore, he has an obligation to demonstrate, one, that the error was a fundamental error, two, that that fundamental error occasioned them a gross miscarriage of justice. And it's our submission that the applicant has failed to demonstrate these very basic conditions to grant a review. In the circumstances, my lords, we pray that the application be dismissed as completely unmeritorious.
We thought it important to have those questions dealt with in interrogatories so that we would not be burdened to have to ask them subsequently in cross-examination. In any case, your ladyship, if the questions are not relevant, how can they be allowed in cross-examination, if that is the position? If the questions are not relevant, if that is the position that's been taken, then they cannot be asked in cross-examination either.
Are you attempting to cross a bridge you have not reached?
Well, I believe you put that bridge there. But with respect, this very simple way of trying to interpret Rule 69C4 would lead to gross absurdity.
The court in a unanimous decision dismissed first the request that was asking that it allows some additional documents to be filed to bolster the review arguments of Mr. Mahama's team, and also dismissed the review itself, saying that it has not met the threshold required for such a review to be granted. Proceedings have been adjourned to Friday for the trial proper to commence, and the various legal teams have been reacting to the directives from the courts.
The refusal of applications are not fair to the petitioner in the light of the past and in the light of what is happening now. So we disagree with the rulings of the Supreme Court. Unfortunately, that's their decision. There's not much we can do. We'll be in court tomorrow.
The law is not about what you want. It is about what you will get. And this business of they're talking about fair hearing and all that. In one of the authorities that their lead counsel, Mr. Tajikaka, quoted, it was stated quite clearly there that speedy hearing is synonymous to fair hearing. So I don't know what this fetish it is about expedition being sacrificed for justice. In the case that he himself, Tajikata, quoted, it was speedy hearing is fair hearing. And I don't really get the complaint. When you come to court and your mind, with all due respect, is jaundiced, that you should expect a certain ruling from the court. That is what is occasioning you when the ruling goes against you. In the courtroom, I heard my sister Marietta also saying that their lead counsel preferred superior arguments. Really? Superior arguments. Indeed, if the arguments were superior, 9 justices will not find that argument not superior. So that position they are canvassing is neither here nor there.
On Friday, when the case resumes, Dr. Michael Pesa-White and the NDC's General Secretary Johnson Esiedun Ketia will be called upon to mount the witness box. Reporting for Joy News on the Supreme Court, I am Joseph Akable.
And that sit-in will be live here on Joy News.